Good afternoon, folks. It's now 1 o'clock, and we're back from recess, and I'll call this meeting back into session. And so if you want to do a roll call.
Commissioner Buck?
Here.
Commissioner Schroeder?
Here.
Commissioner McDaniel?
Here. Okay, thank you. So before we open up the Bighorn Ridge rezoning hearing here, I'd like to turn it over to Commissioner Schroeder for a couple of comments.
Thank you, Mr. Chair. I'd just like to make a comment in the interest of full disclosure. My parents live within the quarter-mile radius of the proposed Bighorn Ridge rezone. I have no financial interest there, but I just wanted to make the applicant and the owner aware of that. And if you would prefer for me to recuse from this hearing, I will do so.
Concerns.
Thank you.
Thank you. All right, with that, we'll open up this Bighorn Ridge rezoning and land use. So, Kelsey, I'll turn this over to you.
Perfect. Good afternoon, commissioners, those in attendance. For the record, Kelsey Lanham with the Elbert County Planning Department, and today I will be presenting Bighorn Ridge rezone.
Hang on just a minute. Hold just a minute. So I'm told we need to open up a hearing, so we'll make a motion to open the public hearing for the Bighorn Ridge rezoning.
I make a motion to open a public hearing for the Bighorn rezone RZ 2023-0316.
Okay, second.
Second.
All in favor? Aye.
Aye.
All right, now you can go. Thank you. Sorry.
Perfect. Like I said, for the record, Kelsey Lanham with the Elbert County Planning Department, and I will be presenting Bighorn Ridge rezone, case number RZ-2023-0316. The subject property is located at 316 Ponderosa Lane. The property has a total of 79.72 acres and is currently zoned agriculture. The applicant representative is Grace Erickson on behalf of the property owner and applicant Gary Hansen. They are proposing to rezone the entire property from agriculture to agriculture residential. And I just want to make note that this application and presentation is strictly for a rezone. So this property, in the next two slides, it will be shown by the big red star. The property is approximately a quarter mile to the east of the Douglas County border, and it's currently and historically been vacant. There is an existing private driveway that accesses the property, but no change of the access or modification is being proposed with this rezone application. The two adjacent properties on the west are zoned agriculture. The properties directly to the north and east are a combination of R1 and R2, with the northeast properties being RA2. The properties to the immediate south are zoned agriculture residential, which is the same zoning that the applicants are proposing for their property. These surrounding properties allow for minimum lot sizes anywhere from 12,000 square feet to 35 acres in size. Like I said, the applicant is looking to rezone the entire property for the purpose of future development. At this time, the county does not have any subdivision applications for this property. Rezoning to agriculture residential, when talking about development standards, it would allow for a 10-acre minimum lot size. And this here is a snippet of their rezone exhibit. I went ahead and outlined the property line in yellow. Like I mentioned, the rezone is for the entire property, which is just under 80 acres in size. Looking at the timeline, Their pre-application meeting was back in March of 2023. Their community meeting was in November of 2023. Formal application was November of 2024. It went through one referral period from November 26th through December 17th of 2024, and it went before the Planning Commission on February 4th of this year. At the community meeting, outside the applicant and some of the family members and applicant representative, there were 17 people in attendance. The concerns with the project included fire mitigation, access, subdividing, removal of trees, water, traffic, wildlife, and property tax increase. The applicant has fully responded to these concerns, and their comment document was provided in the packet. Just a little bit more about the concerns. Fire mitigation will be planned with the Elizabeth Fire District. Access modification is not being proposed with the rezone. At the time of creating the access and road through the development, the applicant has stated that the least amount of trees will be removed, as their goal is to preserve as many as they can. During the future subdivision application, the Division of Water Resources will review the application fully again. However, their approval decree was already included in today's packet as well. A traffic study was also done, and no adverse impacts were found by the Elbert County Public Works. And since the community meeting, the planning department has not received any public comment. Like I mentioned in a few slides back, the Planning Commission was on February 4th of this year. There were 2 members of the public who spoke on this case. One was in opposition while the other was supportive. I will mention that one of the commissioners brought up concerns about the sign posting affidavit for the project. Staff confirmed at the Planning Commission that the applicant was in full compliance with noticing requirements found in the regulations. And these are some of the referral agencies, being Elizabeth Fire, Division of Water, Public Health, Public Works. All comments have been addressed by the applicant, and there are no outstanding objections from any of the referral agencies. The Elbert County zoning regulations require that a rezone application follow the criteria in Article 3, Section C4. The review criteria are: A, conforms to and is generally consistent with the goals of the Elbert County Comprehensive Plan. The rezone does conform with those goals. B, the rezone is compatible with surrounding land uses. The surrounding properties are zoned agriculture, agriculture residential, residential 1 and 2, RA2. So these zonings allow for various lot sizes. The proposed zoning allows for a minimum of 10-acre lots, like I mentioned. C, the rezone does not adversely impact the provision of public services. The rezone does not impact the provisions of public services. D, does not adversely impact the environment. The rezone will not impact the environment. E, the rezone will not create unreasonable traffic or burden existing road system. The rezone will not cause traffic or burden the existing road system. No change to an existing road is proposed with the rezone. Public Works was a referral agency, and there are no outstanding objections. And F, the rezone will not be detrimental to the present or future inhabitants of Elbert County. The rezone will not be detrimental to the present or future inhabitants of Elbert County. And with that, and based on the review of the approval criteria found in the Elbert County zoning regulations, Article 3, C4, in the findings in the staff report, staff recommends approval with conditions of Bighorn Ridge rezone. The conditions of approval are: One, the applicant will be required to remove the public hearing sign within 7 days of a decision by the BOCC. Number two, the rezone will not become effective until all fees are paid, conditions of approval are met, and the rezone exhibit is recorded. And finally, number three, recordation of all appropriate documentation is to occur within 180 days of the BOCC approval. And that concludes my presentation. The applicant is present today if the commission should have any questions. Thank you.
Thank you. Commissioners, Commissioner Book, do you have any questions?
I actually don't have any questions. This is a straightforward rezone. It's not only compatible, but it's consistent with surrounding land use. You've addressed all of the questions that I had in the packet and then in the presentation. No questions or concerns.
Okay, Commissioner Schroeder.
Is there anything that the applicant or owner would like to add to the presentation?
Good afternoon, Commissioners. Grace Erickson, Providence Consulting Applicant Representative. The only thing I have to add is that this is a family development. It's a bit unique. The development is intended to serve the family of the property owner, so these lots would not be sold. That is in your narrative, but it wasn't in the presentation. And that's all I have to add.
Okay, thank you. Anything else, sir?
I do not have anything.
I don't have any questions. Thank you.
Thank you.
All right, are there any public comments? All right, seeing none. Additional questions from the board before we move on? Everybody's good? Okay, I'll ask for a motion to approve or object.
I'll make a motion to approve RZ 2023-0316, Bighorn Ridge rezone.
Second.
All in favor, sign of aye.
Aye.
Motion carries. All right, I'll make a motion to close this public hearing for the Bighorn Ridge rezone, RZ 2023-0316. Is there a second? All right. All in favor, aye?
Aye.
All right, motion carries. All right, thank you. Right, next item on here is the Independence Plan Unit Development, PUD, Amendment 4, under 2024-7520, and the Planning Manager, Jennifer Jones. But before we do that, I need to have a motion to open the public hearing for this Independence Amendment. Is there a motion?
Mr. Chair, I make a motion that we open a public hearing on Independence PUD Amendment Number 4, PD-2024-7520.
Is there a second?
Second.
All in favor, aye?
Aye.
Aye.
All right, Ms. Jones?
Thank you. Good afternoon, Commissioners. I'll present Independence PUD Amendment Number 4. Quick summary, the site location is the equivalent of what will be Independence Filing Number 5, which is essentially the rest of Independence that has not yet been platted. The site size is about 377 acres. It's obviously all already zoned PUD. And the request before you is essentially a couple simple text amendments. These have to do with lot widths and side yard setbacks. It's really clarifications. So there's no substantial changes. Clarifications, and they are consistent with a previous amendment that was also approved. So just for clarification to get our bearings here, the area outlined in teal roughly depicts the area that will be filing 5 and the area that is applicable for the proposed PUD amendment. As mentioned, the PUD amendment is for text only. There's no other changes to the graphic. These changes would apply to the area that was indicated, which is equal to what will be filing 5. To get really confusing, this proposed amendment number 4 is the same as the previous approved amendment number 3, which applied to filing 4. And I do have a graphic on the next slide to help clarify that a little bit. And again, the filing 4 that's being proposed today does not apply to filings 1 through 4, only to the future filing number 5. And to illustrate that, I do have this colored graphic to show you essentially how the filings equate with the PUD amendment numbers. So you can see red is filing 1, which was the original PUD, 2 and 3 filings, PUD number 2. PUD number 3 is shown in green, is the equivalent of filing 4, and that is the exact same PUD amendment that is being proposed to you today for the area shown in yellow, which is filing 5, the rest of the Independence area. So to get into the details of the changes, the extent of the changes are shown on this slide. Is really for clarification. So a range of lot widths is what was previously written in there, which was a little bit confusing. And so the request is to amend that to a minimum lot width for clarity moving forward. There's also an added note having to do with side yard setbacks, only on that alternative single family. So clarifications only, no other changes are associated with this request, only this table that you see here on this slide. And just a quick highlight of the timeline. This was submitted in September. It did go through a review cycle. All the requirements for notice have been met. It was reviewed by all the applicable agencies. There were no, hardly any comments at all, nothing outstanding, as this amendment is very slim in what it's requesting to change. So no concerns from our review agencies. There have been no public comments received through today. And this item did go before the Planning Commission in a public hearing in December of 2024. There was no public comment received at that hearing, and the Planning Commission did vote 6-0 to recommend approval with conditions. To summarize, the approval criteria is the PUD amendment consistent with the comp plan. There's not an issue with consistency. Compatible with the surrounding land uses. Again, there's no proposed change to any land uses. Will it adversely impact the public services or impact the environment? That is not it will not do that. No additional traffic congestion or burden on the road system, and would not be detrimental to current or future residents of Elbert County. The Planning Commission, based on review of the approval criteria found in the Elbert County Zoning Regulations, Article 7, letter F, and the findings in the staff report, recommend approval with conditions of the Independence PUD Amendment number 4. The 3 recommended conditions are the standard conditions having to do with taking down the sign, becoming effective upon recording and payment of any fees, and recording within 180 days. That concludes staff's presentation. Staff is available to answer any questions you may have, and the applicant is also available.
All right, thank you. So we'll invite the applicant up for questions from the board.
My name is Mark Kiefer. I'm with Norris Design, the planning consultant for this project. It's a pleasure to meet you, new commissioners. Just as a clarification, and by the way, my address is 1101 Bannock Street, Denver, Colorado, 80204. So appreciate your staff, Ms. Jones' update on this. Just to add a few more bits of information that are relevant to this hearing today. This amendment does not change the density or the intent of the original PUD that Independence had approved several years ago. So the densities remain the same. The setbacks, for the most part, do remain the same on all of the single-family detached lots. And also, just to note that while Ms. Jones had mentioned that this particular amendment, Amendment 4, was approved 6-0 by the Planning Commission, the same amendment had been approved by both the board and the Planning Commission unanimously when we took this before you all with filing 4. So why that had happened, just to clarify some of the confusion why this amendment is up again, when we were moving forward with filing 4, subdivision filing 4, we had to take care of this issue that had propped up in the staff review of that original subdivision plat. And frankly, the history behind why this amendment exists today is it was developed, cooperatively with your staff because it raised some confusion when the staff reviewers for the county were looking at subdivision plats, and they couldn't make it was difficult to make an interpretation of lot widths on each of the plats. So the simple explanation would be, like if you consider a cul-de-sac or a curved road, and a fairly a tight turn on a road, the lot widths in front change considerably, which changes the definition of whether it's the size lot, the average standard lot, or the large lot definition. So through that process that we went through an amendment, or with the final plat for number 4, we came up with this solution that instead of having a range, let's just have a minimum standard, so that there's a black and white rule that your staff, as well as our designers, could work with in terms of determining what that middle, or that basic lot width calculation would be. So that's really the origination of this application. It was really more of a house cleaning issue to clean up some ambiguity with the PUD, and that's why we're here this afternoon. I'd be glad to answer any questions.
Okay, Commissioner Buck?
Yeah, I have just a couple questions. I know there's no density change, but my concern is during the planning process, a cul-de-sac should have been able to be properly planned for. So it's concerning to me when we're doing a 20% adjustment on a large estate lot size, let's say, from 100 feet to 80 feet. Oh, and that's not a range. There was no range. Now, the average alternative single family and the standard single family, there was a range, and that was given originally, and now we're at the lower end of those ranges. But the large single family and the estate lot single family, we are below those ranges in the large single family, and we just didn't have a range for the estate size. So that's concerning to me, that really what happened here and where did that extra land go? Why didn't we plan for it? Those kinds of questions is what's coming to my mind.
Well, the simple answer, again, to a complicated question, if we didn't have the one, so like, for example, the estate lots, we would never have estate lots on this project. They would all be classified as standard single lots, even though they're fairly large in square footage. The result of a cul-de-sac or a curved road where the front lot becomes narrower, it would just kick into a lower category of lot definition. Does that make sense?
It does.
So, in this case, it's 6 of one, half a dozen of the other. What we're doing right now is allowing for something to be called an estate lot with a smaller side yard or lot width calculation, but the square footage, as you can see, still remains the same, like the 21,780 square feet minimum.
Okay.
So the lot definition, we want to maintain the lot definition based on the area calculations, not the widths of the lots.
Gotcha. Okay, that makes sense. How many homes in each one of those tranches, if you will, are we talking about? So, for example, standard single family, that minimum lot width went from 59 to 69. How many would be in that category?
Overall project.
Yeah, well, in terms of this, what we're looking at today, is that 50 homes? Is that?
I would say a large number of the single-family homes in Independence today are in that standard single-family category. There are many of them that are also in that large single-family category as well. I would say right now, between those two definitions, all the lots within Independence are either one of those two categories.
Can you talk a little bit about the side yard setbacks for us?
Sure. Those are for duplexes. Duplexes are allowed within the PUD, but one of the questions that had come up again from your staff, as well as just anticipating something in the future. We don't have any plans right now for duplex development within the project, but in the event that there were lots that are currently allowed within the PUD, at least that definition now is the side yard definition is made clearly in the PUD that would allow for two adjoining homes or attached homes, meaning a duplex. So it's, again, a matter of interpretation. There are other portions of the PUD that do allow for duplex homes today.
Okay, thank you. That's all I had.
Mr. Schroeder?
No, I appreciate the clarity, and I appreciate the clarity of the chart that does take all that ambiguity out of there, and it makes it very clear for everyone. I appreciate the comments on the duplexes. I know we have crossed that bridge in the past, and it just helps with our housing needs and help bringing the prices down. Get more people into home ownership is a great thing, and so I appreciate the presentation.
I don't have any questions, sir. Thank you.
Thank you.
Are there any public comments? All right, seeing none. Any additional questions by the board before I call for a motion? All right, so I'm going to ask for a motion.
Mr. Chair, I move we approve Resolution 25 TBD, Independence PUD Amendment Number 4, PD-2024-7520, with the conditions of approval that were listed.
Is there a second?
Second.
All in favor, aye?
Aye.
Aye. Motion carries. I'll accept a motion now to close the public hearing for Independence PUD.
Mr. Chair, I move we close the public hearing on Independence PUD Amendment Number 4, PD-2024-7520.
Is there a second?
Second.
All in favor, aye?
Aye.
Aye. Motion carries. All right, thank you. Next on the list, we have the Digby zoning authorization. So before we go into that, I'll ask for a motion to open this public hearing for this.
Mr. Chairman, this one is not a public hearing.
Not going to need a public hearing? Okay, thank you for that. So with that being said, then I'll turn it over to you, Ms. Jones.
Yes, sir. Thank you. I did not prepare a presentation for this one. It's just sort of a quick discussion with you all based on the memo that was in your packet. Staff is looking for direction or authorization from the board to begin a county-initiated zoning process for a piece of property located south of Kiowa that was recently de-annexed from Kiowa. So therefore, it currently has no zoning, as zonings don't transfer between jurisdictions. So if the board authorizes staff to do that, we can begin that process per the Elbert County zoning regulations and get that property zoned back to ag.
Okay. Is there any citizens' comments? All right, we'll ask for a motion to authorize the planning staff to begin the county-initiated zoning process for the subject property.
I make a motion to authorize planning staff to begin the county-initiated zoning process for the subject property.
Second.
All in favor, aye?
Aye.
Aye.
Motion carries. All right. Seems like we've come to the end of the day here, so I'll accept a motion to adjourn.
Mr. Chair, I move we adjourn.
Second. All in favor, aye?
Aye.
Aye.
Thank you. Thank you, everyone, for coming today. Thank you.